I want to answer the question as to whether or not you can write your own will. I'm attorney Vernita Williams. I practice law here in South Florida in the area of probate and estate planning. Occasionally, I get asked the question, can I just write my own will? Well, the answer is yes, but the better question is, should you write your own will? The answer to that is no. Now, there are many reasons why you shouldn't do that. I'm just going to tell you today in part one, just 5 of the reasons why you should not write your own will. Reason number 1, sometimes when non-attorneys write their own will, they don't follow all of the required formalities. For instance, in the state of Florida, you're supposed to have 2 witnesses. Well, I've known of people who wrote their own will and they didn't know that, so they didn't have the required number of witnesses. And although all of the family members clearly understood what the deceased parent intended, one of the children decided to capitalize on that mistake and made it such that that will was declared null and void because it didn't have enough witnesses. The second reason is because many times when people try to do their own will, there are execution inconsistencies. When a will is prepared, there should not be any inconsistencies. There shouldn't be different dates in the will. For instance, the people who are witnesses should not sign and date on a particular date, and then the notary sign and date on another date. Those kind of inconsistencies makes the will questionable and probably subject to being declared null and void. Also, there shouldn't be scratch outs and white outs and things like that in your last will and testament when it is done. So any kind of execution inconsistencies, different dates, scratch out, white outs, suspicious looking things should not be done. That's another reason. The third reason is a lot of times when laymen who don't understand the details of what's necessary when you prepare a will, when they prepare a will, they give gifts to minors that are worth more than $15,000. Here in the state of Florida, if you give a gift to a minor and it's worth more than $15,000, then you have a problem. You just created a need for a guardianship case. The guardianship case will be expensive. It will require regular reporting and a whole lot of things, and it will cost attorney's fees that will eat up the money that should be going to the minor. So many laymen don't understand how to include minors in a will in a manner that they don't create the need for a guardianship court case and attorney's fees associated with that. A fourth reason is sometimes I've seen wills drafted by people who are not attorneys that don't even have a personal representative. That's a big deal. Every will should appoint a personal representative. The fifth reason is sometimes people who don't understand how to draft wills may leave out what is called the residual clause. The residual clause is a catch-all phrase that tells you if a specific person wasn't given a specific item that is owned by the decedent at the time of death, then here's who to give it to. If you leave out the residual clause, there will be some people who were not intended to receive things that will receive by default or by operation of law. Those are just 5 reasons. Not enough witnesses, execution inconsistencies, improper gifts to minors, excluding or leaving out a personal representative, and not having a residual clause. So now if these things are Greek to you, if what I'm saying is confusing and not making sense, that's all the reason why you shouldn't be doing your own will. So, can you do it? Yeah, you can do it. Should you do it? No, you should not do it. So, let me give you some additional information. If you need additional information on what you need to do and things you need to look out for, you can go to my website. There you can get 25 estate planning tips to help you avoid legal nuisances and nightmares. And you can also get a checklist of 25 things you need to do to set your affairs in order. If you'd like to call me with questions, comments, and suggestions, call 786 831 9483. That's 786 831 9483. But can you do your will? Yes. Should you do it? No. Thank you for listening.